Hello. Good afternoon, everyone. Today we're going to talk about inadmissibility and waivers. Understand the consular interview. We're going to help family navigate the path of U.S. immigration. As you guys all know, there is the three common pathway to have green card in these countries. The first one, it's family based, employment based, and humanitarian. But today we're going to talk about when somebody is inadmissible. We're going to talk about the waivers, understand the consular interview. Again, my name is BOT. I am an immigration consultant. I am part of Willa Law Academy Group. I am a legal rebels, and today we're going to have a comprehensive of inadmissibility and waivers. So let's get into it. What is inadmissibility? So the definition is a person may be legally blocked from entering the US or receiving a visa even if petition is approved. So let's say you have an I-130 approved or you inside of the United States, you have any application approved because you're admissible, you cannot get a benefits, or if you're outside of the United States, you cannot have a visa. So the common reason for somebody to get is to get inadmissible or the student, they are immigration violation, fraud or misrepresentation. If you have lied in the past and they discover that, if you have let's like we spoke of in our previous video, if you have sent our frivolous asylum, if you have a criminal record, or if you have some type of health or security grounds, those are the reason that could stop you from getting a way to get in the United States, even though if you qualify for those three pathway: family, humanitarian, or humanitarian. So let's talk about consular review. So if you have a petition approved and you're outside of the United States, you're going to do consular processing. The consular processing, the steps are you file the your visa application to the embassy, and after all the review, you're going to have your interview. And in this interview, the USCIS officer will check for inadmissibility. So they do a deep background scrub. The embassy officer conduct a thorough review of your entire history, prior entry, overstay, arrest record, security background, medical examination, or prior removal. So all of those things that could make you have a black or inadmissible thing, they go over all of them. So after your interview, you could either receive a 221G, they're gonna ask you to send more document, or you're going to have a visa refusal based on inadmissibility. So let's talk about what is unlawful bars. If you enter the United States, you are supposed to stay for a period of time. Let's say with a visa for 6 months, and you stay more than 100. You stay unlawfully for a certain amount of time. You're going to trigger bars. And if you stay for 180 days or plus, you're going to only trigger 3 years bar. So that means you bar from coming back to the United States for 3 years. If you went over 1 year, you're going to trigger a 10 years bar. Let's say David stay 14 months after his visa expire, or even though your visa don't expire, and you let's say you have a period of time to stay on your visa 6 months, even though if you have a 5 year visa, after the 6 months you need to leave, or either way you're going to be illegal. Let's say David stayed 14 months after his visa expired. Upon leaving, it triggered a 10-year ban. It now require a waiver to return. Even though his family filed a petition for him, he's going to need 10 years to come back. So we're going to talk about I-601A provision waiver. This is a type of waiver. So if you stay in the US, you file before leaving for your interview, Your unlawful presence only waive the presence bar. Requirements must show extreme hardship to qualify a relative, spouse, or parent. Status require an approved immigration. Immigrant petition. Let's say if you have an approved immigrant petition, you have unlawful entry, let's say, so you are inadmissible, you cannot get your green card, so you're going to require to file I-61A to get it approved and leave, go to the interview and to consular processing and come back after you get approved. This one, I want you can only file it if you stay in the US before you're leaving for your interview. You must have it approved. You stay unlawfully, you trigger a few bars. And the requirement is just like you must have family member, your spouse or parents that you, if without you, those people gonna go through it. You're going to show, you must show extreme hardship to qualifying relative. Status require approved immigration. So for criminal issue or false claims relationship, this require another type of waiver. This is another process. Let's talk about fraud and misrepresentation. One of the most serious ground for permanent inadmissibilities is fraud and misrepresentation. Misrepresentation is like when you lie to the in the past to the USCIS. So the standard I-61 waiver is used to overcome inadmissibility finding after the consular denial. It covers misrepresentation and fraud, certain criminal ground, health-related ground requires this one requires strong evidence. There is some type of criminal inadmissibility the I-61 cover. It's some offense is like drug offense, theft, fraud, and crime involving moral turpitude. Crime involving moral turpitude, you need to file a I-601. The officer going to review the evaluate sentence, conviction detail, and the timing of the offense. Not every arrest is denied, but any conviction create significant risk. If you, they always says if you send in your application out and you've been arrested, you have a misrepresentation, you lie, you must stop and file I-601. You need to prove extreme hardship to your family. Let's say waiver require proof of hardship beyond the normal emotional difficulty. Hardship category. You need to have some medical, chronic condition, mental health report, caregiver needs. Let's say your family have some type of chronic condition, mental health report, and then you can, if they leave, if you leave, that will cause them harm. Financial, let's say your whole you don't have a household, loss of primary income, they go into debt, inability to work, you inability to work upward. Safety, you have, then you're going to go to different dangerous condition in the applicant home country. Educational, disruptions with children's schooling or special training. Let's say you have your family, and if you leave, they're going to go all the things that I just said. You're going to you need to file a waiver because of that. The first one is medical, the second one was financial, and the third one is safety educational. The hardship must be very strong. It must be very strong. It cannot be weak. Weak evidence, let's say my spouse will miss me and be sad. No, this is just considered as just a consequence of separation. This is not hardship. You need to be like, okay, my spouse is diabetic and depend on me for transportation and financial support. Those, and you need to have proof like doctor later bills, therapy and report that could support whatever that you said, and you will have your waiver approved. Let's talk about the common mistakes. Let's say you're hiding things to USCIS. Let's say you're concealing prior arrest or border crossing leads to permanent fraud filing, weak packet, filing your waiver without enough document or poor financially, and you leave prematurely. You leave before the waiver. is approved, you're going to get bar permanently. Real case scenario. Example. Callers enter without inspection, stay 3 years, trigger 10 years bar. A I-61 provision waiver is required before leaving. And the other case, if Cassandra lie on her pre or visa application, permanent misrepresentation filing, you're going to need a I-601. There's a difference between I-601A or a I-601 waiver. The I-601A only forgive unlawful presence or bad entry. In the meantime, I-61 just forgive some type of crime, misrepresentation, and etc. If you guys have any question, again, my name is VOT. I am an immigration consultant, and I'm here to answer any question that you guys might have.